So let me start by reiterating what Yusuf has just said. Of course, right to information is very important in terms of holding government, holding the political establishment, if you will, to account. It allows us, the citizens, to know not only what government wants to tell us about what they're doing, but also whatever it is we want to find out about what government's doing. And I think across South Asia, RTI laws have been used to great effect in this purpose, and I won't talk about that. Maybe some of the commissioners that are on the panel will talk about some experiences from their countries. But as I understand the focus of the panel, it's a little bit more specific than that general accountability function. And as I read the title, it's about how we can hold the political establishment accountable to RTI itself, as well as generally accountable. And I think for me, I have identified three key elements to an RTI system which serve that goal, or which may serve that goal if they're done properly, I guess. The first is the extent to which the political establishment, whatever exactly that is covered by the law, which will depend on the text of the law. The second is the extent to which the exceptions in the law exclude key information which is required to hold the political establishment to account, again, depending on the exceptions and how they're interpreted. And the third, slightly more amorphous, is the extent to which the establishment can somehow avoid enforcement of the rules. So I will go through each of these in turn. South Asia's region with quite a few countries in it. I'm going to look just at three countries, obviously Sri Lanka, where this event is being held, Pakistan, we have a Pakistani commissioner on the panel, and also India, because of course it's a leader in the region on this issue. In terms of scope of coverage, I would say overall, all three countries do very well. My organization has developed the RTI rating, a tool for assessing the strength of RTI laws. Probably many of you have heard of it. And I'll drop a link in the chat later on. And out of 30 points in terms of scope, Sri Lanka gets 28, Pakistan gets 25, and India also gets 25. Those are very strong scores, I should mention. In terms of coverage of the executive, Sri Lanka gets 7 out of 8. Pakistan gets 8 out of 8, and India gets 5 out of 8, but mostly because security bodies and research bodies are excluded, not the political establishment. And in terms of legislature, all countries get full points. And I remember very well, and I had many conversations about this very case with Kishali, that one of the first important requests for information in Sri Lanka was for the asset declarations of the Prime Minister and President. There was a bit of a kerfuffle about who the request was put to and who answered the request, but I don't think at any point there was any question whether that information was covered by the law. So I think it illustrates quite clearly the broad scope of coverage. And I would say that your region is very strong in this area, and it's not the case everywhere in the world. For example, in my own country, Canada, our handsome Mr. Trudeau, who I think might be more popular in Sri Lanka than he is in Canada. We just had a third election. We did re-elect that fellow, but only again by a minority government. So showing that he's not that popular. But I think if he were running in Sri Lanka, he might quickly get a majority. Anyway, I mean, Kishali's looking shocked. I mean, as a Canadian Prime Minister, not your own Prime Minister. Anyway, he promised in 2015 that he would extend the scope of coverage of the Act to the offices of the Prime Minister and ministers, because it doesn't cover those offices at the moment. His government did amend the Act, and those amendments were passed into law, but they reneged on that promise. They did not extend the coverage. So we still don't have that coverage. We are currently having another review of the Act, and we'll see if it goes that far. So anyway, you're ahead of us on that issue. Partly that's a question of when the laws were adopted. Older laws, like the Canadian law, tended to focus more simply on the executive, whereas the newer group of laws tend to be broader in scope. Okay, moving on to the question of exceptions. This is a much more complicated issue, and I will here go by country again. Looking at Sri Lanka, there are a few exceptions which I think undermine the extent to which the law holds the political establishment to account. Firstly, the privileges of parliament are excluded. To be perfectly honest, I'm not exactly sure what that covers. I haven't studied the privileges of Parliament Act. Secondly, communications between professionals or the Attorney General and public authorities, which another law renders secret. And that's potentially much broader than the solicitor-client exception or solicitor-client privilege exception that you find in most laws. What we have noted in different countries is that even solicitor-client privilege, which is just one form of professional advice and a highly protected one in every country, even that one is often subject to abuse in the context of government, because government has lawyers which provided all kinds of advice, much of which is nothing to do with legal matters per se. It's policy advice. Even if it's about a legal matter, but it's simply policy advice, much as any other official might provide. We do not believe that that should be covered by an exception, and we think that that exception should be limited in the case of government to litigation privilege or perhaps negotiation privilege, only cases where the solicitor is actually acting as a solicitor in providing advice to government. And the broad solicitor-client privilege exception is not often restricted in that way. Third exception in Sri Lanka is cabinet memos, as long as no decision is taken. That exception is not harm tested, and we deduct a point for that on our rating. But it is at least narrower than many laws which cover all discussions in Parliament and even all advice to Parliament. And when we come to India, we're going to see that their exception is much broader in that case. We believe that it's legitimate to protect the doctrine or the principle of collective responsibility of cabinet, which of course is a key part of the system of government that all of our countries share. But what we think should be the case is that the exception should be limited to cases where disclosure of the information would exactly harm that collective responsibility, and not some other notion such as cabinet memos or information provided to cabinet or whatever it is. Coming to Pakistan, there are a trio of exceptions which apply until a final decision has been made. Minutes of meetings, notings on the files, and intermediary opinions. All of those are excluded until a final decision has been made. We recognize that it's important to protect the free and frank exchange of advice within government, and that sometimes advice is sensitive and that it needs to be covered by an exception, but all of those exceptions are not harm tested and are not limited to that idea, so we deduct points for that. Pakistan allows the minister in charge of the federal government, I presume that's the prime minister, after some procedural rules, to exempt information. That, of course, is a discretionary power, not linked to any interest or any harm, and we don't consider that to be legitimate. And of course, when we talk about accountability of the political establishment, presumably that power would be used precisely in cases where the political establishment wished to avoid accountability through the disclosure of highly sensitive and highly embarrassing information, not highly sensitive information. So not a good exception in terms of accountability. And then there's another exception in Pakistan where information is furnished on the condition of confidentiality. I believe that's primarily to protect third parties and not the government. It's not harm tested, and it could probably be abused by the political establishment. Okay, moving on to India, cabinet papers and deliberations of the Council of Ministers are excluded, although decisions and the reasons for those decisions are not excluded. So we can see here a much broader version of the cabinet exception than you find in Sri Lanka. So that's very problematical. It doesn't identify any interest and certainly isn't harm tested. Again, we see in India parliamentary privilege. And then finally, in India, information provided in confidence by foreign states, no harm test there. And I'd contrast that with the exception in Sri Lanka, which applies only where the disclosure of the information would be prejudicial to relations with other governments. So that's a proper exception, whereas the Indian one is too broad. Again, looking globally briefly here, although I've identified some problematical exceptions in the region, I would say the region is not bad at all. And in many countries, for example, you find blanket exclusions for internal advice. And that, of course, puts a huge limitation on the ability to hold the political establishment to account. Finally, and briefly, I will look at the issue of enforceability. And I think there are two issues here. The first is whether officials are responsible for breaking the law, for refusing to disclose information, because at the first instance, a citizen asks public authority for the information, and if the public authority refuses to give it without grounds, that would be a barrier to accountability. Of course, they can appeal to the commission and they can go through the procedures, but it still puts a drag on accountability, if you will. All three countries have good rules on that. It's a disciplinary and a criminal offense in all three countries. But I think that India and Pakistan have the strongest systems, because in those countries, the information commissions can directly sanction officials who breach the law. And I know in India that has been credited with enormous power in terms of enforcing the act. And then finally, a quick point about the binding nature of decisions. In all three countries, the decisions of the information commissioners are formally binding. I note that only in Pakistan is the mechanism which I prefer in place, which is that the decisions failure to follow the decisions is treated as a form of contempt of court and can be dealt with through the courts as a contempt of court. I have seen that tool be very effective in other jurisdictions, and I'd be interested to hear from the other commissioners as to whether there's been any problems in their countries with the enforceability of decisions. With that, probably I've spoken a little bit too long. I'll stop and let others in. Thanks.